Most revocable living trusts put your kids at risk of losing all of their inheritance, and we're going to talk about why that is and what to do about it right now. Hey guys, Elliott Feldman here, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. If you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. So let's talk about why most revocable living trusts put your kids at risk of losing all of their inheritance. The fact is that most traditional estate planning lawyers out there are creating trusts that leave the inheritance to the kids outright. If you ever had a traditional lawyer create your trust, then most likely that trust is designed to hold the assets until your kids are deemed old enough to receive the money being left behind, and then the trust terminates and distributes to the beneficiaries, i.e. your kids, outright. As an example, mom and dad have a trust that says when both of us die, then our son will get 1/3 of the assets in our trust when he reaches the age of 25. Then when our son reaches the age of 30, he will get 1/2 of the remaining assets in the trust. Then when he turns 35, our son gets the remaining balance of assets in the trust. Thereafter, the trust terminates. Then the son owns all of the trust assets now in his name. When you see something like that in a trust, that means that by the time the son reaches the age of 35, whatever is left behind in the trust is distributed outright to the son to be put in the son's personal bank account and titled in the son's name as the new owner, and the trust terminates at that point. Now, you may think that that sounds reasonable because, when the son turns 35, he should be mature enough to handle the assets that are being left behind. And while that may be the case, this is not the best way to leave your inheritance behind to your children. You see, when a trust terminates and the inherited assets are then brought into the son's personal bank account and the assets become titled in his name, those inherited assets then become subject to risk from the son's creditors in a future bankruptcy, or from the son's wife in a future divorce, or from a future lawsuit judgment against the son. And even if none of those things ever become an issue, the son is not incentivized to grow the inherited family wealth, but instead he's incentivized to spend it all on consumable goods and luxuries rather than to create more with it. Trust me, there is a much better way. An alternative to an outright inheritance to your children, outright meaning they both personally own and can personally lose the inheritance, is to gift your assets to your children via a special trust that we call the Lifetime Asset Protection Trust. A Lifetime Asset Protection Trust can be drafted into a regular revocable living trust to give your children full control of the inheritance if you so choose, but at the same time ensure they never own the assets in their name to ensure those assets would never be at risk of a divorce, lawsuit, creditors, or mismanagement. You see, when you leave assets for your children in the name of a Lifetime Asset Protection Trust, the trust is the owner of those assets and not your children. What that means is if there is ever a divorce, a bankruptcy, or a legal judgment, they can only get their hands on what your children own in their name. They can't get their hands on the assets that are owned in the name of the trust. That's what we call airtight asset protection that you can't get any other way. Now, don't worry, if you want to make sure your child has full control and ability to access his inheritance held in the trust, then you can make your child the sole trustee of the trust and the beneficiary of the trust, thereby giving him the control as the trustee to make distributions of the trust assets to himself as the beneficiary without the risk of ownership. From a management perspective, the Lifetime Asset Protection Trust also can be used as a vehicle for financial education about investing, giving, and even business by allowing the beneficiary child to become a co-trustee of the trust with another co-trustee, a financial professional, someone that you've chosen in trust to support their financial education, like a trusted family member, a financial advisor, an accountant. You can even build in provisions to only allow your child to become the sole trustee of the trust at a specific interval or when the co-trustee deems it best to step aside. The options are honestly endless. Most importantly, if you are working with the right kind of lawyer, you can use this kind of planning as an opportunity to hold regular family meetings with senior and junior generations to plan for the passage of your family prosperity. You see, family prosperity goes far beyond the money. When viewed properly, you can see the money that's being left behind from one generation to the next as a catalyst for family connection, passing on family values, and the opportunity to clarify how the family uses its resources of time, energy, attention, and money. this is what family prosperity planning is all about. So in summary, most revocable living trusts put your kids at risk of losing all of their inheritance because they leave the kids their inheritance outright rather than keep their inheritance protected in a lifetime asset protection trust. If you would like to learn more about how to build a lifetime asset protection trust into your estate plan for what you are leaving behind to your kids, or even for what you'll receive from your parents, you can set up a quick call with me today at myestatemeeting.com. Hey, thanks for taking the time to watch this video. Don't forget to hit that subscribe button and the notifications bell next to it to be notified for new videos I post each week. And if you like it, then please hit the like button. And if you know someone that needs to hear this, please share it with them. If you have a question or comment, please leave it. And if you ever have any questions about this topic or need to talk about your estate planning needs, you can schedule a time to talk with me over the phone for free by going to myestatemeeting.com. That's myestatemeeting.com. Again, this is Elliott Feldman, estate planning attorney at the Elliott Feldman Law Group, where we create estate plans that actually work when your loved ones need it most. Take care.